My report will focus on the European arrest warrant from an active perspective, specifically the issuance of arrest warrants. I would start with a balance sheet. In recent years, I have worked at the Ministry of Justice as the Director General of Judicial Cooperation, so I have a privileged perspective in this regard. I must say that it has been about 20 years since the European arrest warrant has been used in Italy. Next year will mark 20 years. If we were to take stock regarding the inactive European arrest warrant, meaning the use that our judicial authorities make of it, I must say that the assessment would definitely be very positive. The objectives that the framework decision of 2002 aimed to achieve by introducing this first mutual recognition tool in the aftermath of the September 11, 2001 attacks in the United States have been met. The aim was to simplify the delivery procedures. The European arrest warrant replaces, within the European Union, as we know, the traditional historical institution of extradition. There is no doubt that the procedures have naturally been simplified with the introduction of the warrant. There are hundreds, thousands of cases. Just think of the Bataclan case, the attacks in Paris. The attackers who survived and were not detonated were handed over from Belgium to France within a few weeks, if not days. Extradition procedures are much more complex. It can take months in some cases. If we think about certain states, I don't know, the United Arab Emirates, Canada, just to name a few, it can sometimes take years. Extraditions involve the political side, the executive power, as well as, obviously, the judicial authority. In the European arrest warrant, there has been a depoliticization of the procedures, and everything is entrusted to the judicial authority. This has allowed not only to facilitate procedures, but also to establish close contact among the judicial authorities of various countries, thereby creating the mutual trust that is the foundation of all mutual recognition instruments at the Haas Union level. It is certainly a success story. After all, the statistics tell us so. You think that in 2006, a year after the EAW came into force, the Italian authorities had issued 33 EAWs in 1 year. In 2019, 1,430 were issued for a variety of offenses, including investigations related to terrorism, property crimes, fraud, 139 for sexual violence, and more than 300 concerning drugs and corruption. These figures are more or less consistent with the numbers we have seen in recent years. Certainly, it is not a path of sunshine and light. There have been instances where our Court of Cassation has intervened with various rulings that saved a law, Law 69 of 2005, from constitutional illegitimacy, as it presented numerous profiles of constitutional illegitimacy due to its significant deviation from the framework decision of 2002. However, this must also be placed, so to speak, in a historical context. It was a historical period, that of 2005. In 2005, when the EAW was introduced, the framework decision was implemented, which reflected a deep mistrust towards this tool. The European arrest warrant is issued by judicial authorities. The Court of Justice has stated that police authorities, central authorities, and the Ministry of Justice cannot issue arrest warrants at all. More recently, the Court of Justice has also focused on the independence of the authorities that must issue the EAW. It is not sufficient for the EAW to be issued by a judicial authority, but it is necessary for the EAW to be issued by an independent judicial authority. Therefore, public prosecutors who receive indications, orders, or directives from the executive power, primarily from the Ministry of Justice, within the legal framework of the issuing state, are not an authority and cannot be considered a legitimate authority to issue the EAW. In Italy, we must distinguish between executive EAWs and judicial EAWs regarding the authorized authorities. The EAW can be based on a final conviction or a detention order in prison. Now let's address the issue of house arrest. In cases where the EAW is procedural and based on a custody order in prison, it is issued by the investigating judge in 95% of the cases. I say in 95% of cases because for a period there was also the issue of whether the Court of Review could issue. And obviously the review terminal, in the case where there was an appeal by the public prosecutor against an order rejecting the application of the custodial measure to be served in prison, the case law has been somewhat fluctuating. There has been a contradiction, and then a ruling from the United Sections clarified the joint actions of 2013, which clarified that it is up to the judge to issue the EAW. Naturally, the judge who proceeds is the preliminary investigating judge, GIP, as he is the only one with the case file and knows what the matter is about, unlike the review court. In the case where the basis for the EAW is a final conviction, it is up to the public prosecutor before the execution judges to issue the arrest warrant. Therefore, the arrest warrant is a distinct act compared to the title, the underlying order to release from detention in prison, or the final conviction sentence. This is important because one of the most significant elements of simplification that the European arrest warrant has introduced is the lack of requirement to attach the custody order or the final conviction sentence. In other words, the public prosecutor issuing the arrest warrant must transmit to the judicial authority of the location where the person has been located and arrested solely and exclusively the European arrest warrant, which is a form of a few pages, the custody order of the accused in prison, and the final conviction sentence do not need to be attached. The possibility of not attaching the order or the sentence, of simply transmitting the may, has I have achieved one, I have achieved, it has one, it has achieved one. It has led to the success of the warrant. Of course, there is the opposite problem when drafting an arrest warrant and transmitting it, namely the need to condense the charges, the facts, and a summary of the events into a few fields in a concise yet exhaustive manner. This summary must be included in the EAW and not attached separately, which has also imposed different drafting techniques on US magistrates. What are the prerequisites for the issuance of the arrest warrant? So, we have the order, we have a final conviction sentence. What are the conditions under which the arrest warrant can be issued? First of all, the unavailability of the convicted person or the suspect. Irreparability refers to, or rather is sufficient with, the report of searches that is drawn up. Therefore, the order is not executed, the sentence is not executed, the judicial police draft the report of searches, and this is sufficient for the issuance of the arrest warrant. Possession of 0.5 grams of hashish, which are truly trivial cases. The other issue regarding the active EAW, which is currently relevant in light of the recent discussion about the case of Ilaria Salis, is whether there exists a mutual recognition instrument for house arrest, since this is not an arrest warrant but a national offer, which, as you know, is not definitive and is subject to the measure of custody by the authorities. In prison in Hungary, however, the question remains: the arrest warrant implemented in Italy could also be applicable in relation to house arrests. And on the other hand, we were discussing the other day another conference with my colleague. Moreover, the Supreme Court itself has told us that the decision by the investigating judge to refuse the issuance of an EAW, because the underlying title is that of house arrest, is an abnormal act. On the other hand, we must also note that many countries in the European Union do not have house arrest among their mandatory measures and do not follow it. Germany, Malta. I remember a case in Malta where an arrest warrant was issued. The basis was house arrest, and the Maltese judicial authority arrested the person and put them in prison. And I also remember the polite suggestion of the lawyer saying, here we need to enforce house arrest, and to carry out house arrest here we have to serve the prison sentence in another country, which is quite paradoxical. When the framework decision 829 came into force in 2016, which was implemented in Italy in 2016, there was a discussion about whether this measure, this framework decision, could be applied to house arrest, and this has been debated recently in reference to the case of Laria Salis. Here we have some inconsistent rulings from the Court of Cassation. So, what is the issue here? This framework decision refers to the obligation to remain in a specified location, possibly at designated times. Obligation to remain in a specified place, possibly at set hours. What does this mean? Does it include house arrest? Or does it refer to the obligation to reside? There are few legal precedents, but some decisions from the Court of Cassation have interpreted this obligation to remain in a specific place, possibly during set hours, as corresponding to our measure of house arrest. Recently, on January 22nd, 2024, there was another ruling from the Court of Cassation, specifically from the third section, which includes a colleague, a president of Amicis, who is highly competent in the matter, though it should be noted that the others were also competent. However, this section deals with judicial cooperation and has narrowed the scope of application of this decision and framework, arguing that the obligation to remain in a specific place clearly refers to the obligation of residence, which also includes the possibility of imposing the obligation not to leave the residence during certain hours of the day. Of course, you understand well that the risk we are facing is that this measure of house arrest, which is in the interest of everyone, both the judiciary and the legal profession, could and should find a broader scope of application, but instead may end up not falling within the scope of either the framework decision of the European arrest warrant or other framework decisions. Yes, the European arrest warrant, once completed, must then be transmitted to the Ministry of Justice. Why to the Ministry of Justice? The Ministry of Justice actually plays exclusively a supportive role in the context of the European arrest warrant, assisting the judicial authorities. It has no decision-making role. It is transmitted to the Ministry of Justice because the translation of the EAW is the responsibility of the Ministry of Justice. Why is it the responsibility of the Ministry of Justice? Because essentially at the moment the EAW is issued, it is unknown where the person is. Therefore, when the person is located and arrested abroad, depending on the country where the person is located and arrested, the Ministry of Justice arranges for the translation into the language of the country, accepted by the country where the person has been arrested. The transmission of the EAW to the Ministry of Justice can be carried out by either the public prosecutor or the investigating judge. And at that point, the EAW can also be sent simply via email through certified mail. Of course, it is not necessary to transmit the EAW in paper form. At this point, there is also a notification in the Schengen Information System. The notification in the Schengen Information System is equivalent to a request for provisional arrest. Essentially, when a person is untraceable, what is done is to simultaneously issue the European arrest warrant, enter this person into the database of the Schengen Information System, and also request the Ministry of Justice to disseminate the search internationally. This means that the person will be sought within the European Union and outside of it. Once the person has been entered into the Schengen Information System, to remain within the European Union, at that point, the Italian judicial authority does not need to do anything further, as the person will be located and arrested in another country of the European Union. At that point, the passive procedure opens in that country, and the judicial authority of the country where the person has been arrested, located, and detained will decide on the delivery. Cases, more information may be requested. The mechanism is provided for by the European arrest warrant. Our judicial authorities, the Ministry of Justice, can receive additional information both regarding the fact and the applicability of the fact within a legal framework that allows for the delivery of the person. I will conclude by referring to another aspect that perhaps concerns us. Technicians. More, which is the role of Eurojust in the execution of European arrest warrants. Why do I mention the role of Eurojust? Because in several cases, we should not always think of a European arrest warrant in the context of an investigation. Increasingly, within the same investigation, multiple arrest warrants are issued against different individuals that need to be executed simultaneously in various countries. In this case, you will understand that coordination is essential, because if certain individuals, often in proceedings related to organized crime, but not exclusively, are located and arrested in one country, a day before, it is evident that the operation will inevitably be affected by this arrest. For the judicial authorities, it is not easy to coordinate these large investigations and operations. In this context, Eurojust plays a fundamental role because it allows for the simultaneous execution of various measures through various contacts with national members in different countries. I will stop here. Of course, if you have any questions, I am at your disposal. Thank you.